Today we're going to continue to go over the types of court systems in America, and we're going to focus particularly on the Supreme Court today. So we've got a couple goals for today. Number one, to explain the structure and function of the Supreme Court, to explain how members of the Supreme Court are selected, and to explain the processes followed by the Supreme Court in making a landmark case decision. So if we start out, let's take a look at the justices. You know that the Supreme Court is the highest court in the land. It means there are no higher courts. It is the court of final appeals. And because of that, we have 9 justices currently serving on the Supreme Court. Now that is not set in the Constitution. You could have more, you could have fewer. Many times in our nation's history we've had fewer. We know that FDR tried to pack the court by having 14 justices. That didn't work out so well for him because Congress basically just adopted the tradition of 9 justices. So even though technically we could add more or we could take away, because the Constitution doesn't say the number of justices on the Supreme Court, generally speaking, we have stuck with 9 justices in the most recent history of the Supreme Court. So justices, of course, are appointed by, you guessed it, the president, and confirmed by the Senate, or a part of Congress. So pretty basic stuff. We've already done that when we did legislative. Appointed by the president, confirmed by the Senate. And so if we look at who's on the court today, we need to move past this article from your book because we have new justices. So if we take a look at currently who's serving on the court, the longest serving member was appointed in 1988 by President Reagan, that is Anthony Kennedy, and Neil Gorsuch was the most recently appointed just a couple weeks ago actually, by President Trump. And so you can see some of the background of the court justices. What this means and why this is important, if you're not noticing, a lot of people say Supreme Court justice is even more important than the president himself because of the lasting impact. Ronald Reagan appointed Justice Kennedy in 1988. It's almost 20 years later, and Justice Kennedy is still making decisions long after Ronald Reagan had passed away. And so probably one of the most important things a president can do in his term is appoint a Supreme Court justice, because Supreme Court justices last for a while. The appointment of Neil Gorsuch, it seems likely that he'll be on the court for probably the next 20, 30, 40 years. He could impact the court for quite a while. A little bit about the background of the Supreme Court justices, a little bit about how they rank. You can see most of them are not exactly poor. A good percentage of the Supreme Court justices worth over $200,000, many of them over $1 million. So maybe not your average citizen, but certainly pretty well educated and pretty evenly divided among political party. So, Supreme Court. How long does a member serve on the Supreme Court? Pretty much for life. The Constitution says Supreme Court justices are appointed as long as they have good behavior, which generally means for life. I guess if they went to jail, they could be impeached. Only once have we ever tried to impeach a Supreme Court justice, and that impeachment failed. So pretty much once you're on, you're on. And there's a good reason for this. We want the justices to be removed from any political bias. We know that if you were only serving for 3 or 4 terms and you had to get reelected or reappointed, if you didn't side with the public or you didn't side with the president, there's a good chance that you just wouldn't get voted in or reelected to your term. And because we want the Supreme Court to interpret the Constitution based on what the Constitution says and not based on political feelings, we say that Supreme Court justices are appointed for life. We talked a little bit about federal court justices. They're usually appointed for life, although some, depending on where you're at, if you're a non-Article III judge, you could be appointed from anywhere from 8 to 15 years. But even if you're only up for reappointment or reelection every 8 to 15 years, that's still a pretty long time in a job where you can make decisions without worrying about retribution from the decision you make. And of course, federal justices, just like a Supreme Court justice, could be removed or impeached by the Senate. So this is a clip from the movie House of Cards, and it'll give you the idea of exactly how important the impact of a Supreme Court justice is. So the guy on The right is a guy who is a currently Supreme Court justice. He's getting up there in age. And on the right, you've got a lady who is running for president, but he wants her to be a Supreme Court justice. And listen to why.
Oh, your dissent on Godfrey versus Kent was brilliant, by the way.
My clerks, they wrote it, every word.
So it's time.
Ruth says it is, but I knew before she said anything.
When are you going to announce?
Soon. But I'd like you to say yes first.
To what?
Replacing me. This isn't the disease speaking. I haven't forgotten you're running for president. But Underwood, I'm sure he'd nominate you in a heartbeat.
I am the front runner, Robert. Why would I drop out?
Because this position's for life.
Underwood is going to lose.
You think he'll go down easily? And even if you get the nomination, the Republicans, they'll rip you apart. I'm the swing vote. My seat is important. You can make a lasting difference here.
That is exactly what he said.
His motivations were atrocious, yes, but his logic was sound.
Your mind seems sharp as ever, Robert.
Except for the fact that I can't remember your name right now.
Heather.
Heather. Will you continue to do the work I've done, Heather?
I can't.
So as you can see, he's more concerned about the legacy that she could leave as a Supreme Court justice rather than what she could do in 4 or maybe even 8 years as president. If we look at some of the impact and we look at what Supreme Court justices have done, you can take a look at this chart. You can pause it if you want a little bit more time with it, but we're going to move on. So the Supreme Court itself. The Supreme Court has one very, very, very important power, and that is the power of judicial review. So where did the court get this power from? Well, if you said the Constitution, you are incorrect. Basically, the court gave themselves the right to judicial review in the case Marbury versus Madison. You don't need to know the details of the case. It's all online if you want to know a little bit more. But the end result of Marbury versus Madison is that basically the Supreme Court says that they have the right to judicial review. They have the right to review any case and decide if it violates the Constitution or if it is basically illegal. And so this is important. The power of the court to determine if a law or an act of Congress or some other act of the government, does it violate the Constitution? And if it does, then we know that it is no longer valid and the Supreme Court can reinterpret the law or maybe even strike it down. That's where we get to the idea of precedent. Now, precedent comes from an idea known as stare decisis. This cool guy in the picture, he loves stare decisis. And what stare decisis means, literally in Latin, do not disturb what has already been settled. Basically saying if we've already reviewed the facts of the case, if we've already looked at all the evidence, we've already ruled on one case, every future case should be settled in exactly the same way. And when we settle it exactly the same way, we are creating what is known as precedent. Laws in the American legal system and most of the Western world are based off of the idea of precedent. Once we settle a case, once we come to a conclusion on a case, all future laws will be based on the previous cases. So let's look at the diagram below. So if past case A has facts 1, 2, and 3, and those same facts are identical in case B, then the judgment that we use for case A should also be used for case B. We should decide cases that are exactly the same in the same manner. Once a precedent is set, it has the immediate effect of law. So the new interpretation, the new precedent is as if Congress had passed a new law, or as if the government passed a new law. So These are the same as essentially when a Supreme Court justice is interpreting law, they are creating a new law. And so we once again see the appeal system whenever a lower court creates a ruling, they have a precedent. When an appeals court creates a ruling, they create the new precedent. And of course, the Supreme Court creates the final precedent. So if you're wondering how does all this Supreme Court stuff work, let's take a look at the process of getting a case to the Supreme Court. It's not easy to do. In fact, we know that out of roughly 10,000 cases proposed a year, only about 100 of them actually get heard. So about 5% of all cases that go to the Supreme Court come from original jurisdiction. They're pretty rare that a case of original jurisdiction goes directly to the Supreme Court. A little bit more common, about 30% of the time, Supreme Courts will get their cases from the state courts. So people will appeal through the state court system, and if they're not happy, go to the Supreme Court. But what is most common in about 65% of the cases will go through the federal court process and eventually make the case to the Supreme Court. So your book has a diagram that says basically the same thing. You can pause it and take a look at it. So well, we just said that there are roughly about 10,000 cases that get proposed to the Supreme Court each year. Because they get to choose what they want, they will only choose something that has a very important constitutional impact and something that they're willing to rule on. Because of that, they only hear approximately 1% of those cases, or approximately 100 cases per year, which is not a whole lot considering how many cases get filed. Now, the way we determine if one of these cases is going to be heard is through using what is known as the rule of 4. So all 9 justices will get together and they will look at a case and they will read the case, and if they think that it is worth reviewing, they'll take a vote on it. And if at least 4 justices agree that it's a case worth hearing, they don't have to agree on the result, just agree that it's worth reviewing, then they will issue what is known as a writ of certiorari. And what certiorari means is literally send up the records, send up the documents. What they're saying is they're asking the lower courts to give them all the evidence and all the facts of the case, and then they will review it as well. So we're going to watch a clip from a movie called Gideon's Trumpet, where they're asking for a writ of certiorari. They're reviewing the importance of the case, they're going to vote on it, and decide whether or not to put it on the docket. The docket is the schedule of the Supreme Court.
Complex charges against him?
No, sir. Breaking and entering with intent to commit petty larceny.
Bets against Brady. Says he's out of luck unless he can show special circumstances or some disadvantages. He decided that 20 years ago.
He's not claiming any special circumstances. He just says that under the Constitution, a poor man is flatly entitled to have a lawyer help in his defense.
He's asking us to change our minds, huh?
Yes, sir.
Well, we seem to do that every 20 years or so. Tell the clerk of the court to write to the state of Florida, ask for a response. That'll clarify the legal issues, fill in the factual background. And do up a memorandum for the justices. We'll deal with this in conference, just like any other petition for cert.
Yes, sir. Thank you, sir.
Thank you, Arthur. 13 minutes.
So they're moving to their chamber where they're about to listen to a couple different cases, or at least the arguments as to whether or not they should hear a couple cases.
This morning we have 2 jurisdictional statements asking to hear appeals, 26 petitions for cert, 10 paupers applications, and 3 petitions for rehearing. So I'd like to get started. Shall we begin with the Louisiana Freedom Rider case?
I think we should not only grant the petition for review, but we ought to reverse the convictions for lack of supporting evidence right now.
I agree. 6 Negroes convicted of a breach of the peace for trying to desegregate a Shreveport bus terminal. The only thing they did wrong was to violate the custom of segregation. And that ground is constitutionally impermissible.
Anyone else? How many to grant the petition for review? How many to reverse the conviction now? Gideon versus Cox.
So there you have it. You see how the Rule of 4 process goes. Next, we take a look at once they have issued the writ of certiorari, once they have gone through the Rule of 4 hearing, they will put a case on the docket, which means put it on the schedule. And then the next step comes in is both sides submit what is known as a written brief. The brief is the argument that each side is going to make. It's all the facts, it's all the evidence. Remember, there are no witnesses in a Supreme Court case. It's just looking at the application of the law. So both sides submit a brief, basically their argument, and they also get the opportunity to submit what is known as an amicus curiae brief, a friend of the court brief. Unlike any other case, any other court system, in a Supreme Court case, even if you are not a party to the case, if you've got a vested interest in the case, you have the right to submit your ideas and your opinions, which are what is known as an amicus curiae brief or a friend of the court brief. The next step is oral arguments. In oral arguments, once the justices have reviewed the briefs, they will go into the courtroom and they will hear from the attorneys, and each side gets 30 minutes. That's it. The court could choose to extend it, but they do that in very rare occasions. Usually they stick with the 30 minutes for each side case, and then it's just a back and forth between the lawyers and between the justices. And that's what we'll see in this video here, again from Gideon's trumpet.
Name's Jacob. You know what I find interesting? In the ordinary criminal case, the state has all the advantages. But now, in the Supreme Court, Gideon has Abe Fortas on his side. Plus you, plus me. The state of Florida has a young assistant attorney general who's probably never set foot in this room before. This once, things evened out. Don't go feeling sorry for the son of a bitch until we win. Huh?
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Number 155, Clarence Earl Gideon, petitioner, versus H.G. Cochran, Jr., Director, Division of Corrections, State of Florida.
Counsel are present.
Mr. Fortas.
Mr. Chief Justice, may it please the court. This case presents a narrow question unencumbered by extraneous issues. Clarence Earl Gideon is supposed to have broken into the Bay Harbor pool room and stolen some wine, some cigarettes. And
so you see they're citing constitutional facts and arguments.
He was arrested and put on trial. He asked the judge to appoint an attorney to defend him, and the judge refused. Thereupon, Gideon did the best he could to defend himself. He was convicted, sent to the penitentiary for 5 years. The record does not indicate that Gideon was a person of low intelligence, nor that the judge was unfair to him. But to me, this case shows the basic difficulty of Betts versus Brady. It shows that no man, however intelligent, can adequately conduct his own defense.
That's not the point, is it, Mr. Fortas? In the Betts case, this court did not go on the assumption that a man can do as well without an attorney as he can with one, did it? Everyone knows that isn't so.
I entirely agree, Mr. Justice.
So it's a back and forth between the justice and the judge.
That a man cannot have a fair trial without a lawyer. But the Betts case held that this consideration was outweighed by the demands of federalism. In other words, the Betts case expressed the feeling that this court had at the time, that the state of Florida or any state should have the right to decide for itself whether defendants in their courts should be entitled to counsel. The Supreme Court of the United States should not impose that requirement upon them. But, Mr. Justice, this court has held many times that when there are special circumstances, a defendant is entitled to counsel in the state courts. I have now read all the cases on right to counsel questions, beginning with the famous case of the Scottsboro Boys in 1932, and it is a fascinating inquiry. As I read the opinions of this court, I hope I may be forgiven for saying that my heart was full of compassion for the judges having to review those records, look for special circumstances which might entitle a defendant to counsel. Such case-by-case supervision of the state courts by the Supreme Court cannot be wholesome. Intervention should be in the least abrasive, least corrosive way possible. Of course, this special circumstance approach is wrong. How can a trial judge, when a man is arraigned, look at him and say there are special circumstances? Does the judge say, you look stupid, or your case involves complicated facts? It is administratively unworkable.
The states are recognizing that.
Some of them are, Mr. Justice. Professor Camisar's research indicates that 37 states now provide counsel for poor people in all felony trials. 8 others frequently do so as a matter of practice, and 5 make no regular provision for counsel except in capital cases. But I do not agree with any implication in your question that this movement by the states to act themselves argues against the step forward now by the Supreme Court. I do believe that the growing acceptance of right to counsel by the states makes a reinterpretation of the Constitution easier. I see my time is almost up, so I will try to sum up. I believe this case dramatically illustrates that you cannot have a fair trial without counsel. Under our adversary system of justice, how can our civilized nation pretend that there is a fair trial without the counsel for the prosecution doing all he can within the limits of decency, and the counsel for the defense doing his best within the same limits? And from this clash, the truth will emerge. I think there is a tendency to forget what happens to these poor, miserable, indigent people in these strange and awesome surroundings. Sometimes in this court, there is a tendency to forget what happens downstairs. I was reminded the other night as I pondered this case of Clarence Darrow when he was prosecuted for trying to fix a jury. The first thing he realized was that he needed a lawyer. He, one of this country's great criminal lawyers.
Mr. Fortas, what are the limits of what you're asking? Now, at what stage of a criminal case must a lawyer be supplied? And in what kinds of cases?
Do we have to pass on that?
No, sir, not at this time, but I will give my opinion anyway.
So even after a Supreme Court goes to oral arguments, that doesn't mean the case has been decided. The next step is what is known as conference. And in conference, the Supreme Court justices go to their private room, nobody's allowed in, and it is a completely 100% private discussion where they argue the evidence that's been presented by both sides and basically come to the conclusion of what they want the result to be. Once they do this, they draft their opinions, and we'll talk about the 3 types of opinions, and after that they announce their decision. So when they announce their decision, they also announce the opinions, which are the written ideas of the court. They are the written down arguments of the court for why they decided the case they did. And so there are 3 types of decisions. A majority decision, this is the official ruling of the court. This is the one that goes on record. This is the one that matters the most. It also sets the precedent. So when we review for precedent, the majority opinion tells us not only what the ruling is, but why the justices thought what they did and how the law should be applied in the future. The concurring opinion are those justices who agreed with the end result of the majority, but for a different reason. So maybe they agree with the majority, but they've got a different legal reason for agreeing. They're part of the concurring opinion. And then something kind of unique to the American system, the dissenting opinion. The loser basically gets to write up what their arguments are for. Now, they don't mean anything. They're not legally binding. The dissenting opinion doesn't really change the law. But the one reason why they do want to write a dissenting opinion is so in the future, if they are reviewing the precedent and they're looking for some evidence to overturn a case, one of the things that they might look towards is the dissenting opinion for ideas. How do judges make these decisions? Well, there are a number of unofficial and a number of official ways. The only reason why a justice is supposed to make a decision is based on the law, based on the Constitution of the United States. But we know that over time, justices are influenced by a number of things. We know that Congress and the President attempt to influence Supreme Court justices. Sometimes they're able to, sometimes they're not. Supreme Court justices, for better or worse, look at existing laws. Of course, they look at the facts of the case. They look at the precedent. They look at all the previous court cases. They see how previous cases were ruled on as compared to the current case, and they apply that. The only official thing they're supposed to use, the Constitution. Each of them has a personal philosophy, which is not supposed to find their way into the rulings, but they usually do. Public opinion, what is popular, sometimes finds its way into cases even if it shouldn't. So for example, for years the Supreme Court ignored the issue of gay marriage, and when public opinion seemed to be turning in favor of gay marriage, the Supreme Court found a way to rationalize it, which is a good thing. We're actually seeing adaptations and changes. And then finally, the justices will discuss things with other judges. Sometimes when they go into conference, they change their mind. Other times they don't, but that is all part of the process. So, if we want to listen to Justice Elaine Kagan explain how she makes decisions, let's take a look.
I mean, maybe sometimes we take it a little bit far, and sometimes you'll see an argument where you think, oh, that poor lawyer, he just really never had a chance to tell us the basic theory of the case. But mostly that can happen in briefs when all of us read the briefs very carefully, and the lawyer has the opportunity in the briefs really to say what he thinks of the case, and the argument is for us to say, well, yeah, we've read your brief, we know what you think of the case, but here are the questions that inspired in us. Here are the concerns we have, or here are the uncertainties that you left open, and use oral argument in order to do that. So we know what you think, but what's really important is that you respond to our questions and our concerns.
So argument still has a value, even though you come in with vast knowledge of the case at hand and what the issues are.
I think it definitely does. Now, sometimes it will have more of an effect than other times. Sometimes you have a sense that people have come in and they've basically, they've read the briefs and maybe they've had experience in similar kinds of cases and they basically know what they think. Other times you'll see a much more open, exploring set of questions, and you can see that the justices are struggling with some new issue or with some different aspect of an issue that they haven't confronted before. So sometimes it really makes a difference in terms of help me to try to figure this out, Sometimes maybe a little bit less so. Sometimes in those sorts of cases where people have figured it out a little bit, maybe the justices are using the questions almost as much to talk to their colleagues as to get information from the lawyer. And that's also a value of oral argument, because we don't talk about the cases together beforehand. And so oral argument provides the first chance for you to see what your colleagues might think about a case, what's worrying them about a case, what interests them about a case, and for you to suggest to them what you think. And so part of oral argument is that, too, is the justices a little bit talking to each other, kind of through the lawyer. And the lawyer is just this person who happens to be there.
Facilitates.
Yes, exactly. Facilitates the conversation among the justices.
So there you have it, Justice Kagan giving you her ideas and opinions on some of the insights into how she makes her decisions and how the court makes their decisions. Thanks for joining us today. I hope you have a wonderful evening.